Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the community caretaking doctrine, the First Amendment, and disorderly conduct, and is brought to us by Fire's channel. Be sure to check out the description below and give them the credit that they deserve. On February 9th, 2018, Sergeant J. Riggin of the Vermont State Police initiated a traffic stop on driver Gregory Bombard in St. Albans, Vermont, because he believed that Mr. Bombard had raised his middle finger at him as he drove past his cruiser. The interaction that followed was captured on Sergeant Riggin's dash cam.
You need something? You need something? Yeah. No, it looked like you put me out when you were going by there. Looks like you went like this to me as I was driving by you. Did you not do that?
No, you might have thought I might be stretching. I was doing this.
Okay, so you didn't...
No.
Okay, you didn't intentionally do that then?
I thought I flipped you off.
Yeah, it looked like you looked right at me and looked like you stuck your middle finger up in my face.
No, I was doing this. Yeah. You must be really sensitive if it's super flipping you off.
Well, I don't even make it personal, you know. I mean, you looked right at me, and I don't know if you were lighting a cigarette or you had a...
Well, I had a cigarette, but I was doing this.
First of all, I'm not an overly sensitive person, and it's the first time in 12 years I've ever stopped someone who I thought put me off, so I don't like that insinuation. You know what I'm saying? In talking,
I thought I flipped you off.
I want to make sure that you're all right. Yeah, it's an unusual behavior.
It's unusual behavior.
You may not have been doing that, but I think you can agree that if someone was looking for the attention of a trooper, they're probably going to find it by giving them that type of negative signal. Do you agree with that?
No, I don't know, because I don't understand that.
If somebody were to do that, can we? That may not have been you. But can we agree? If somebody did that for a trooper, they're obviously looking for their attention.
No, I wasn't looking for your attention.
I'm saying if someone did that. I'm trying to put you in my mindset from what I was thinking for a moment. Now that I'm talking to you, I realize that maybe that wasn't the case. Right? You don't strike me as someone who would do that. I don't know that until I have a conversation with you. Agree with that? I don't know you until I have a conversation with you.
Okay, so I have a question. If someone flipped you off, What is the citation? What's the crime?
So if somebody flicks me off,
yeah.
I don't know if they're signaling to try to get my attention because they need assistance or they need to have a conversation. Because obviously it's not normal behavior, so I'm going to have that conversation. Right? It's not normal. I'm telling you, out of thousands of public interactions, I've never seen that.
Sergeant Riggin claims that he stopped Mr. Bombard because he thought that he was quote-unquote flipping him off, arguing that he thought the gesture was an attempt to get his attention or signal for help. We will discuss the First Amendment protections for the middle finger later in this episode, but for now, it is important to note that there are some circumstances where officers can initiate vehicle stops out of concern for the driver's safety. While traffic stops generally require officers to have at least reasonable suspicion of a crime or traffic violation, under the so-called community caretaking doctrine, officers may initiate stops without any suspicion of wrongdoing in certain emergency situations. As the Supreme Court of Vermont explained in the 2013 case of State v. Button, quote, "In recognition of the fact that one of the essential roles of police officers is to enhance public safety by assisting those in distress, courts have recognized a so-called community caretaking basis for a lawful warrantless seizure. The propriety of a traffic stop based on the community caretaking doctrine turns on whether there were specific and articulable facts objectively leading the officer to reasonably believe that the defendant was in distress or needed assistance, or reasonably prompted an inquiry in that regard." In the Button case, the court ultimately concluded that the detention in question was not justified by the community caretaking doctrine, noting that, now quoting again, "specific and articulable facts, not conclusory speculations, are required to support a traffic stop under the community caretaking exception." The court concluded by stating that, quote, "The trooper could have taken steps short of a traffic stop, such as slowly driving by defendant's car while looking through the driver's window to see whether defendant needed help. Instead, he activated his blue lights and restrained the defendant's liberty. If a police officer wants to check on someone who may be in distress, there are usually ways to do so short of a seizure. In this situation, although Sergeant Riggin claimed to interpret Mr. Bombard's alleged use of the middle finger as some sort of request for assistance, the middle finger has a widely known meaning that has nothing to do with asking for help, and it seems unlikely that a court would conclude that Sergeant Riggin's claimed belief that Mr. Bombard was seeking his assistance by giving him the middle finger was in any way reasonable. As such, it is probable that a court would find that the traffic stop was not justified by the community caretaking doctrine.
At least didn't catch my attention, but it was so obvious what you did. So I won't take up any more of your time.
Well, I'm going to file a complaint with you.
You're more than welcome to. It's Trooper Reagan out of the Salvas Barracks.
But I don't understand why, like, you thought this was off.
I was going by there, and your middle finger was extended while you were looking at me.
Maybe I was doing this.
Well, I also see that you had a cigarette in your hand.
Yeah.
And so it's possible that you had one hand up while your cigarette.
That would be considered freedom of expression. So I'm going to file a complaint against you.
So actually, you're more than welcome to. So here's the issue.
Yeah.
Is that although maybe freedom of expression, it is so unusual that it requires intervention to make sure that you don't need help at some time. Are you trying to signal my attention or something? Okay, so it may be freedom of expression, but it crosses the line, whereas it is so unusual that it requires intervention. And I'm not going to delay any more than I need to. Listen, sir, once I realize that you weren't flipping me off, you're free to go. You understand?
You don't realize I flipped you off.
Once I realize
what if I did flip you off?
Then we have a conversation about what's appropriate. So I have other things to do than to be.
So if I did flip you off,
have a good day.
Sergeant Reagan tells Mr. Bombard that since he did not give him the middle finger, he is free to go. And when Mr. Bombard asks what would have happened if he did flip him off, Sergeant Reagan ends the encounter without answering. We have discussed First Amendment protections for the middle finger in previous episodes of ATA, and I've included links to those episodes in the description down below if you are interested in learning about this topic in greater detail. In general, however, courts have found that the First Amendment applies to more than just so-called pure speech, and that gestures, such as the display of the middle finger, fall within First Amendment protections for so-called expressive conduct. For instance, in the 2022 case of Radwan versus Manuel, the Second Circuit Court of Appeals, which has jurisdiction over Vermont, held that, quote, although the gesture generally known as giving the finger is widely regarded as an offensive insult, it is a gesture that is generally protected by the First Amendment. As such, it is highly likely that a court would conclude that if Mr. Bombard did in fact direct the middle finger at Sergeant Reagan as he drove by, his expressive conduct was protected by the First Amendment and therefore could not justify an arrest or detention on its own.
Over the fact as he pulled away, he called me and said, you, with the bird. I'm going to arrest him for disorderly conduct. There are multiple people around there. 240 Song, send me another unit to Brainerd Street in the city. So, on Brainerd and off on North Main Street, another unit, please. Okay, so now you're under arrest for disorderly conduct. Get out of the car.
I'm under arrest for disorderly conduct. What did I do?
All the people there saying you and calling me all the people there in the public, that's a crime, sir. So get out of the car, you're under arrest.
How am I under arrest for disorderly conduct?
I'm not going to debate this with you. Please step out of the car. You are under arrest. Step out of the car.
How is that disorderly conduct, sir? How is that disorderly conduct?
Although the first interaction...
I just got up. I'm having a coffee.
Listen to me. Ask me a question. Although the first interaction may have been an error, the second one certainly was not. And while your window was down, with your middle finger extended, you said, quote, yelled it, and then said, as you drove away. And all that public there heard it and saw it. So that is disorderly conduct 101. Step out of the car.
Sergeant Reagan alleges that Mr. Bombard's use of profanity and the middle finger, when the public could allegedly hear him, constituted disorderly conduct. According to Section 1026 of Title 13 of the Vermont statutes, quote, a person is guilty of disorderly conduct if he or she, with intent to cause public inconvenience or annoyance, or recklessly creates a risk thereof, uses abusive or obscene language. Now, while Mr. Bombard's use of profanity could arguably constitute abusive language, in the 1996 case of State versus Reed, the Supreme Court of Vermont held that the so-called abusive language provision of the statute cannot be applied to speech that, although vulgar or offensive, is protected by the First Amendment, and that, therefore, the statute can only prohibit the use of so-called fighting words. In other words, the court concluded that, now quoting, prosecution under that provision is appropriate only when a defendant's spoken words, when directed to another person in a public place, tend to incite an immediate immediate breach of the peace. Although some states have recognized that the fighting words doctrine has less force when the speech is addressed to a peace officer engaged in their official duties, the Vermont Supreme Court determined in the Reed case that the disorderly conduct statute could still apply to fighting words directed at police officers, while acknowledging that, quote, courts must take cognizance of the special circumstances involved in prosecutions for verbal abuse of police officers. In this situation, however, it is unlikely that a court would find that Mr. Bombard's speech rose to the level of so-called fighting words that could incite an immediate breach of the peace. While Mr. Bombard did direct profanity at Sergeant Riggin, he did so while he was driving away from the traffic stop, and did not even speak loudly enough for the dashcam to record what he said. It is therefore unlikely that a court would conclude that this speech rose to the level of fighting words, as there was a very low probability of an actual violent reaction causing a breach of the peace from Sergeant Riggin.
Step out of the car.
I'm having problems. I have a lot of...
Step out of the car. Or step out of the car, you're going to be ejected from the car.
How am I going to
Step out of the car.
Can I meet you at the barracks?
No, you cannot. Step out of the car, you're under arrest.
Can I call your
Do not.
supervisor?
We'll be at the barracks when we get there. Step out of the car, you're under arrest. Step out of the car, I'm going to make you.
But, sir, can you explain to me how that is...
It's disorderly conduct. It is tumultuous behavior of all the motor vehicle traffic there. That's You cannot do that. It's tumultuous. It's profane behavior in public.
I don't understand that.
Step out of the car. I'll lock the door and step out of the car.
Oh, my God, I can't believe this.
Step out of the car.
You're serious, sir.
Walk back here.
Oh, my God.
It wasn't a problem until it became a problem. You understand that?
Are you kidding?
I'm going to put the hood on my... Hands on the hood.
Oh, my God.
Hands on the hood.
Come on.
And put your right hand behind your back.
Oh, my God, sir. You're kidding.
Other
My
hand.
car is
Other
running,
hand. Other
sir.
hand. I'll take care of it. I'm here.
I cannot believe this, sir. I cannot believe this.
The first one may have been there, and the second one certainly was
How
not.
is it disorderly conduct? I'm not being disorderly. How is it causing disorderly?
Now, we can maybe agree to disagree, but yelling, saying you with your hand out of the window in front of what probably
I was a little pissed because you
probably
thought-
were dozens of people, if not over 100 people, in very busy Main Street traffic. Now, that's disorderly conduct 101. That first thing may have been an error, then after that, it certainly wasn't. But now I'm wondering,
How is that disorderly?
but now I'm wondering if maybe you actually did do that as I thought you originally did. Because only somebody who then would have the audacity...
I was smoking a cigarette and I was
you may let me speak now. Someone who has the audacity to do that. Someone who has the audacity... I told you, I've made thousands and thousands of car stops, and I don't remember any time I've ever seen someone consciously flicking the bird, so now I'm convinced that you did. Especially that behavior to actually get to the end of the stop. Okay, so you are under arrest, and that's the end of the story.
Whatever. I don't know what to do here, so I'm going to have to...
What we're going to do is just be compliant.
Well, I am, but I'm not going to answer my questions, I guess.
I'm
worried about my car.
I'm not intending to ask you the questions.
Sir, can I please go?
No. Nope. That ship sailed.
Oh my God, I can't believe it. Oh my God.
I'm all set now.
After his arrest, Mr. Bombard's car was towed, and he was held in custody for over an hour before he was issued a citation for disorderly conduct. While this charge was pending, Franklin County State's Attorney Jim Hughes added another count of disorderly conduct, claiming that Mr. Bombard had obstructed traffic as he was moving back into the travel lane after the initial stop. A judge dismissed this second charge of disorderly conduct after determining that the dashcam video did not show Mr. Bombard impeding motor vehicle or pedestrian traffic. However, Mr. Bombard's motion to dismiss the first count of disorderly conduct was denied, and the case was scheduled for trial. Although the prosecution eventually dismissed the charge on January 18, 2019, according to Attorney Hughes, he only agreed to drop the charge in exchange for a $250 out-of-court donation to a charitable organization, because although he did not want to spend any more time on the case, he believed that Mr. Bombard needed to, and I'm quoting, learn a lesson. When asked about this agreement, Mr. Bombard's attorney stated that he was not aware of the particulars about any donation, and confirmed that his client did not admit to any wrongdoing. On February 4, 2021, with the assistance of the Vermont chapter of the American Civil Liberties Union, Mr. Bombard filed a lawsuit against Sergeant Riggin and the state of Vermont, alleging violations of his free speech rights, illegal seizure, retaliation, and false arrest. As of the date of writing this episode, Mr. Bombard's lawsuit is still pending. Overall, Sergeant Riggin gets an F for maintaining a hostile and authoritarian demeanor throughout the encounter, initiating 2 illegal traffic stops on Mr. Bombard for engaging in First Amendment protected speech and expressive conduct, and likely arresting Mr. Bombard without probable cause to do so. Now, while Sergeant Riggin claimed that he originally pulled over Mr. Bombard because he thought he needed help, I find this explanation to be highly unbelievable, as the meaning of the middle finger is commonly understood, and no reasonable person would believe that someone flipping them off was actually asking them for assistance. The fact that Sergeant Riggin was so offended by Mr. Bombard's subsequent use of the middle finger shows that he clearly knew the meaning of the gesture, and makes me more than confident that he never believed that Mr. Bombard was in any sort of distress. Rather, it seems like Sergeant Riggin attempted to frame his seizure of Mr. Bombard in a way that could be justified under the community caretaking doctrine, despite the clear unreasonableness of his argument, because he knew that he did not have the reasonable suspicion necessary to conduct a routine traffic stop. This encounter demonstrates how officers can easily run afoul of the law when they allow their thin skin and hurt feelings to dictate their actions rather than the Constitution. State's Attorney Hughes also gets an F for pursuing unfounded charges against Mr. Bombard, showing a flagrant disregard for the protections to free expression granted by the First Amendment, and requiring Mr. Bombard to make an out-of-court donation in exchange for dismissal of the charge in order to quote-unquote teach him a lesson for exercising his First Amendment rights. While there is at least a cognizable argument that Mr. Bombard's speech rose to the level of disorderly conduct, although I personally believe it is a very weak argument, there is absolutely no justification for adding an additional charge of disorderly conduct for Mr. Bombard's non-existent obstruction of traffic. What the dashcam actually shows is that Mr. Bombard started to pull into traffic, then stopped to allow a vehicle to pass. The fact that Attorney Hughes would add this baseless count of disorderly conduct to Mr. Bombard's charges is highly concerning, as is his requirement that Mr. Bombard make a charitable donation to receive a dismissal. And in my eyes, these actions demonstrate a sort of personal vendetta against Mr. Bombard in retaliation for his use of offensive but constitutionally protected speech against a police officer. Mr. Bombard gets an A, because although the speech he directed at Sergeant Riggin was in no way polite, I strongly believe that it was protected by the First Amendment, and Mr. Bombard did an excellent job in taking effective legal action after his unlawful arrest and prosecution. While Mr. Bombard probably should have exited the vehicle more quickly on Sergeant Riggin's order to do so, I understand that he was in shock and was attempting to reason with an officer who was trying to arrest him for constitutionally protected activity. And while I would never recommend that a citizen direct the middle finger at an officer, it is expressive conduct that is protected by the First Amendment and cannot be constitutionally criminalized. I commend Mr. Bombard for fighting the criminal charges against him and pursuing legal action by filing a lawsuit, and I hope that he obtains the outcome he deserves in his civil case. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.